Please see from question number 131, Constitution of India. Please listen to me. Which article states that a person cannot be convicted except in case of violation of law by him? It also negates double punishment for the same offense. It also guards against the person being compelled to give evidence against himself. And a person cannot be punished for an act if it was not considered a crime when it was made. This is stated in Article 20 of Indian Constitution. Question number 132. Which article holds that there shall be no deprivation of the life and liberty except for the procedure established by law? This comes under Article 21. Which article relates to protection against arrest and detention? Article 22. Question number 134. Which article says that no person can be arrested without informing the person of the cause of his or her arrest, and the arrested person should be placed before the magistrate within 24 hours. Such a person cannot be denied the right to consult lawyer of his choice. However, this does not apply if the arrested person is an enemy or an ally or hold under preventive detention. Question number 135. Which article or articles deals with the right against exploitation? So Articles 23 and 24 deals with the right against exploitation. Which article prohibits traffic in human beings, beggars, and other forms of forced labor and declares them as punishable offense? This comes under Article 23. Question number 137. Which article deals with child labor? Article 24. Article 24 deals with child labor. Question number 138. Which article prohibits the employment of children below 14 years of age in factories, mines, or any other hazardous industries or jobs? Article 24. Question number 139. Right to freedom of religion is contained in which article or articles? Right to freedom of religion is contained in Articles 25 to 28. Question number 140. Which article says that all persons in India are equally entitled to freedom of conscience, propagation, and preaching of religion of their choice, and none can be forced to adopt any religion? This is stated in Article 25 of Indian Constitution. Question number 141. Which article gives freedom to set up and manage religious institutions, etc.? It guarantees that every religious group can establish their institution, manage their affairs, and acquire property of their own. This is stated in Article 26. Question number 142. Which article prohibits imposition of taxes on religious grounds? Article 27. I repeat this once again. Which article prohibits imposition of taxes on religious grounds? It is Article 27. Question number 143. Which article says that religious instructions in institutions mainly maintained wholly by state funds have been prohibited? Private institutions can, however, maintain their religious character. This is stated in Article 28. I repeat this question once again. Which article says that religious instructions in institutions maintained wholly by state funds have been prohibited. And private institutions can, however, maintain their religious character. This is stated in Article 28. Now, question number 144. Cultural and educational rights are contained in which article or articles? Cultural and educational rights are contained in Article 29 and 30. Question number 145. Which article ensures to the minorities the rights to have their distinct language, script, language, and culture of their own? It also prohibits any kind of discrimination on the grounds of religion, race, caste, language to admission to any of the institutions wholly or partially maintained by the state. This is present in Article 29. Question number 146. Which article ensures the minorities the right to establish their own educational institution? And the article further maintains that the state shall not make any discrimination in giving grants to such institutions. This is stated in Article 30. Question number 147. Which article existed in the chapter of the fundamental rights, but later it was removed? I repeat this question once again, very, very important. Which article existed in the chapter of the fundamental rights, but later it was removed? This is Article 31. Now, what is Article 31? Article 31 of the Indian Constitution originally dealt with the right to property, specifically focusing on the compulsory acquisition or acquisition of property by the state. It guaranteed that no person could be deprived of their property except by the authority of law. It also stipulated that compensation must be paid for property acquired and that the law could not be challenged in court for inadequate compensation. However, this Article 31, was removed from Part 3 of the Constitution by the 44th Amendment Act, 1978. Question number 149. Why was Article 31 removed? The right to property became a hurdle for land reforms and other socio-economic policies aiming to reducing inequality. To allow more freedom for the state in acquiring land for public welfare, the 44th Amendment 1978 was enacted. Now, question number 150. What is 44th Amendment Act 1978? The 44th Amendment Act 1978 repealed Article 31, that is, removed the right to property from the list of fundamental rights and making the right to property a constitutional right. And a modified version was inserted as Article 300A in Part 12. Article 300A in Part 12. Now, what is this Article 300A? Article 300A of the Indian Constitution addresses the right to property, stating that no person shall be deprived of his property save by authority of law. Introduced by the 44th Amendment Act of 1978, it replaced the right to property from being a fundamental right and made it a legal right. This means the government can't take someone's property arbitrarily. It must follow a lawful procedure, even when acquiring property for public purposes. Question number 152. How fundamental rights are protected? Or the question is asked like this: how our fundamental rights are protected? Answer. Article 32 deals with the right to constitutional remedies. It maintains that an individual may move the Supreme Court or the High Courts for enforcement of rights if violated. The enforcement of fundamental rights can be done through various writs, and they are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Parliament may empower any other courts also to exercise these powers. The right guaranteed by Article 32 cannot be suspended except as provided by the Constitution. Question number 153. What is Article 32 of Indian Constitution? Article 32 of the Indian Constitution is the right to constitutional remedies, which allows citizens to approach the Supreme Court directly for enforcement of their fundamental rights if they are violated. It is considered the heart and soul of the Constitution, as it provides a mechanism for redressal of grievances when fundamental rights are infringed. Direct access to Supreme Court. Citizens can directly approach the Supreme Court for redressal if their fundamental rights are violated. This is stated in Article 32. Power to issue writs. The Supreme Court has the power to issue various writs, including habeas corpus, mandamus, prohibition, quo warranto, and certiorari to enforce fundamental rights. Now, enforcement of fundamental rights. The primary purpose of Article 32 is to ensure that fundamental rights are not merely theoretical, but are enforceable in practice. Now, judicial review. Article 32 also empowers the Supreme Court to review the constitutionality of laws and executive actions that may infringe upon fundamental rights. If a citizen's fundamental right, like freedom of speech, right to life, etc., is violated, they can directly go to the Supreme Court under Article 32 to seek relief and have their right enforced. The Supreme Court can then issue orders or writs to address the violation. What is Article 226? Article 226 of the Indian Constitution grants High Courts the power to issue various writs to enforce fundamental rights and other legal rights. These writs include habeas corpus, mandamus, prohibition, quo warranto, and certiorari. It essentially empowers High Courts to act as a guardian of justice and legal rights within their respective jurisdiction. Now, elaboration. Power to issue writs. Article 226 allows High Courts to issue directives, orders, or writs to any person or authority, including the government, within their jurisdiction. The scope of power. This power is broader than that granted to the Supreme Court under Article 32. High Courts can issue writs for enforcing both fundamental rights and other legal rights. Now, types of writs. The writs that can be issued include, first one is habeas corpus, to secure the release of a person illegally detained. Mandamus, to compel a public authority to perform its statutory duty. C. Prohibition, to prevent a lower court from exercising jurisdiction beyond its powers. Now, quo warranto, to inquire into the legality of a person's claim to a public office. And certiorari, to quash the orders of lower courts or tribunals. Now, public interest litigation, what we call PIL. Many PIL petitions are filed under Article 226 to raise issues of public importance and seek redressal. Enforcement of rights. Article 226 ensures that the rights of citizens are protected and that government authorities act within the limits of their jurisdiction. Question number 154. What is the difference between Article 32 and Article 226? Article 32 and Article 226 both relate to the issuance of writs, but they differ in the scope and jurisdiction of the powers. Article 32 grants the Supreme Court the power to enforce fundamental rights across the entire country, while Article 226 empowers the High Courts to issue writs for both fundamental rights and other legal rights within their respective territorial jurisdictions. Now, basic differences. First one is jurisdiction. Article 32 allows individuals to approach the Supreme Court directly for the enforcement of fundamental rights, regardless of where the violation occurred. Article 226, on the other hand, empowers High Courts to issue writs within their territorial jurisdiction or even outside if the cause of action arises within their state. Now, scope of writs. Article 32 restricts the issuance of writs to the enforcement of fundamental rights only. Article 226, however, allows High Courts to issue writs for the enforcement of fundamental rights as well as for any other legal purposes. No obligation to approach the Supreme Court. While Article 32 provides a direct and obligatory avenue to the Supreme Court for enforcement of fundamental rights, Article 226 offers a broader recourse to High Courts. Territorial limits. The Supreme Court's jurisdiction under Article 32 is not limited by territorial boundary, while the High Court's jurisdiction under Article 226 is limited by its territorial jurisdiction. Now, question number 155. What is habeas corpus? The literal meaning of habeas corpus is you should have the body. That is, the judge or court should and must have any person who is being detained brought forward so that the legality of that person's detention can be assessed. Habeas corpus, in simple terms, is a legal process that ensures a person in custody is brought before a court to determine if the detention is lawful. It's a way to challenge the legality of someone's imprisonment or detention, ensuring they are not being held unlawfully. When a person is imprisoned, allegedly, without procedure established by law, the court can command the authority detaining him to produce him in court and to submit the cause of imprisonment. He is asked to show cause why the writ be not issued. In case the court finds that there are no sufficient grounds of detention, the court passes an order that the applicant be set free. But this writ cannot be issued in case of criminal offenses. It is issued against the wrongful detention of a person. Question number 156. What is mandamus? Mandamus means we command in Latin. Mandamus is a court order commanding a public official or body to perform a specific duty they are legally obligated to do, ensuring public officials fulfill their responsibility. A writ of mandamus is an order of the court directing a public authority to perform its duty. If its non-performance causes injury to the petitioner, the idea is that the non-performance of an official act by any authority should not be permitted to injure the legal interest or claim of any person. In other words, it is issued to a lower court, tribunal, or public official to perform his duty, through which the fundamental rights are enforced. Now we will discuss about prohibition. What is prohibition? An order or restraint or stop. A writ of prohibition is a judicial order issued by a higher court to a lower court or tribunal, preventing it from proceeding with a case when it lacks jurisdiction or is exceeding its authority. In essence, it's stay order that stops a lower court from acting outside its legal bounds. This writ ensures that subordinate courts do not act in a manner contrary to the law and maintains judicial discipline by preventing overreach. Now, prohibition is issued for this preventive. It's a preventive measure stopping a case from moving forward when a lower court is acting outside its jurisdiction. It is issued by High Court. It is issued by a higher court, such as the Supreme Court or a High Court, to a lower court or tribunal. Purpose: to prevent the lower court from exceeding its jurisdiction, acting without authority, or violating fundamental rights. Prohibition cannot be issued against private bodies. This writ is not typically issued against private individuals or bodies, but against public authorities or statutory bodies, according to I pleaders law. Scope: it can be issued when a lower court is acting beyond its jurisdiction, violating natural justice principles, or acting under an unconstitutional law, says Juris Center. Now, what is the difference from mandamus and prohibition? Both mandamus and prohibition are writs that deal with court proceedings. A mandamus compels a court to act, while a writ of prohibition directs it to not to act. I repeat this question once again. Both mandamus and prohibition are writs that deal with court proceedings. A mandamus compels a court to act, while a writ of prohibition directs it to not to act. Okay. What is certiorari? A writ of certiorari. A writ of certiorari means to be certified or to be informed. Is a legal tool used by higher courts to review and quash decisions made by lower courts or tribunals. It is essentially a check on the power of lower authorities, allowing the higher court to correct errors or law of jurisdictional issues. Purpose: to ensure lower courts act within their legal boundaries and make just decisions. Issuance: issued by the Supreme Court or High Courts, lower courts, tribunals, or other quasi-judicial bodies. Function: can transfer a case to the higher court or quash an order passed by the lower authority. Scope: originally limited to judicial and quasi-judicial bodies, but expanded to include administrative authorities, impacting fundamental rights. Conditions for issuance. Generally issued when a lower authority acts without or in excess of jurisdiction, violates principles of natural justice, or makes an error of law. What do you mean by quasi-judicial bodies? Often asked, what do you mean by quasi-judicial bodies? Quasi-judicial bodies are administrative entities or tribunals that possess some but not all of the powers and functions of a traditional court of law. They are established to deal with specific areas of law or policy and offer an alternative, specialized, and often more efficient mechanism for dispute resolution than regular courts. Characteristics. They are not part of the regular court system. These quasi-judicial bodies, they are not part of the regular court system. They are distinct from traditional judicial bodies and are often created by government legislation. Now, specific jurisdiction. They typically have limited authority to deal with specific areas like labor, disputes, tax, law, environmental issues, or professional licensing. Adjudicative powers. They can make decisions, interpret laws, and impose penalties similar to courts but within the defined scope. Due process. They often follow procedures and principles similar to courts, ensuring fairness and impartiality. Now, limited review. Decisions of quasi-judicial bodies are often subject to limited review by the courts, but they are not always overturned by regular courts. Examples of quasi-judicial bodies. Examples. Administrative tribunals. These handle disputes related to government actions such as tax appeals, social security claims, or zoning violations. Regulatory agencies. Agencies like the Environmental Protection Agency, EPA, may have quasi-judicial functions when enforcing regulations or issuing permits. Arbitration panels. These bodies resolve disputes between parties through a non-judicial process, often with the goal of reaching a binding agreement. Professional licensing boards. These boards may investigate complaints against licensed professionals and impose sanctions. In essence, quasi-judicial bodies provide a specialized and often more efficient system for resolving disputes in specific areas, supplementing the traditional judicial system without replacing it. Now, we'll study about what is the difference between prohibition and certiorari. This question comes in the examination. The main difference between a writ of prohibition and a writ of certiorari lies in the timing and purpose. A writ of prohibition is issued before a lower court makes a decision aiming to prevent it from exceeding its jurisdiction or acting unlawfully. It's a preventive measure. On the other hand, a writ of certiorari is issued after a lower court has made a decision, allowing a higher court to review and quash, invalidate the decision if it finds it unlawful. It's a corrective measure. Now, writ of prohibition. The purpose of writ of prohibition is to stop a lower court from proceeding with a case or action that it has no jurisdiction to handle or that would be unlawful. Timing. Issued before the lower court makes a decision. Issued before the lower court makes a decision. Nature is preventive. Example. A higher court might issue a writ of prohibition to prevent a lower court from hearing a case that is not within the geographical jurisdiction. Now, writ of certiorari. Purpose. To review and quash a decision made by a lower court that is unlawful or exceeds its jurisdiction. Timing. Issued after the lower court has made a decision. nature is corrective. Example, a higher court might issue a writ of certiorari to review a lower court's decision in a criminal case and find it unlawful due to a procedural error. The last question of the day, what is quo warranto? Quo warranto means by what authority? It is a legal tool used to challenge the legitimacy of someone holding a public office or franchise. Essentially, it's a court order demanding someone show their legal right to hold that position. This writ is issued to declare that the respondent does not legally hold an office or privilege to which he lays claim. In this writ, the court tries the right of the respondent to hold a public office. It restrains a person from acting in a public office to which he is not entitled. So today we could finish from Article 21 to Article 32. Thank you all for attending this online class of ours. So now let's discuss about